Love you, Linda. Love you.
The courthouse the other day in the hallway, you're singing "Oh Happy Day."
One word prayer. Justice, where are you?
All right, Justice Serve TV. We are live in the. Where are we? We're in the Hornet's
Adams
Nest, I think.
Courthouse.
Yeah,
And the Hornet's Nest.
this
Or
is.
some would say the witch hunt for Karen Reed, or is it
Some
the witch
might
hunt
say that.
for, or is it the place where justice has left?
Yes. Will justice make an appearance in the next few weeks or months? Good to figure that out. Michael Bryant here with you, live from Canton. Actually, Dedham. We know that.
Linda Kenny
Bowden,
Bowden,
how are
in
you?
New York, anchoring. I'm good. I hope you had a good weekend. I feel like I've never left. I felt like we have jumped right from our Friday interview with Will DeGlara, and we jumped right over the weekend, and here we are.
I know. Well, I think it's going to get just a little more hectic. Maybe not so much after the first day or so of jury selection. I think it's going to kind of hit a lull of sorts. With this case, I hesitate to say that, but then, of course, opening statements when a jury is finally impaneled, that's going to be a whole different animal.
Yeah, well, lull. How do you define a lull? Okay.
Yeah, lull would be less than insane, I guess, but still above crazy, somewhere in between. Yeah,
it's
so,
maybe a little bit on some of the holidays coming up. Who knows? Maybe things will quiet down just a little bit. But I tell you what, today was not one of those days, Michael Bryant.
No. I mean, there were a few things that were dangling from Friday, but today. Everything that happened today blew those out of the water, right?
Yeah, as a matter of fact, we were supposed to talk about when we first got on the schedule is some of the motions for Friday we didn't get to. It's like they're old. We'll get to those sometime, but today, woo.
Yeah, this is literally the calm before the storm here. A little overcast. I think there was some rain not too long ago. Tomorrow's supposed to be cooler but clear. That's your Dedham forecast for the first day of jury selection. What's going to happen in this building.
Wait a second. Wait. Calm before the storm, did you say?
Yeah,
I think the storm hit coming out of Judge Bev Canone's courtroom today. I think the storm hit the filing of paperwork. I think the storm was huge.
Yeah. I'm talking about physical presence here. Look at it's like a ghost town. I mean, really. There's a local news guy doing a hit right over here for the 5 o'clock news. But otherwise, I mean, when I can park, see that white car right there? When I can park right there, you know that I'm kind of here pretty much by myself. That will not be the case a little more than 12 hours from now. So this building, again, this is my registry of deeds, a la best bathroom in the area. This is where the jurors normally queue up, and then they'll go out this door here, and I'll put a little video on our site just to give you kind of a point of view, subjective view as you walk out those doors, see the courthouse in front of you and the crosswalk. They'll just go down the steps and cross the street there where that car. Hey, buddy, you're in the crosswalk. Get out of the crosswalk. There's that truck in the crosswalk there. They'll go across there, and then up the stairs, and then ultimately to the second floor, where the selection process will begin. I believe, and I'm not 100% sure in this, I believe they'll be filling out the questionnaires when they get there, as opposed to doing it here and taking them across. 250 that were summoned to be here tomorrow. Judge Cagnoni believes it'll be 150 to 175 that actually show up. Nothing happens to the other folks, I guess, but
well, some of them remember that the defense and the prosecution will have gone through and said no already, and they will have been called and say don't bother even coming. Okay?
You think they're going to do that? You think that's going to happen before they do the questionnaires, just based on what?
Yeah.
What'll that be based on?
They may know the person. Sometimes that happens. It won't be a lot, but that happens that you get that. Okay. They'll say, hey, look, this is on. We know that person, and they'll call each other. Of course, I'm not sure they're talking to each other in this case. I know if I think this is all out war. When that happens, you know what you do? You assign one member of your team, which would probably be Miss Little, to talk to another member of the team. I don't know who that would be, and you say you can talk to each other about what we're saying, because if you're the lead, even though there isn't a lead in the defense team, they don't identify like that. You ain't talking to Hank Brennan right now, I don't think.
No, I don't think anybody's talking. I think everybody's girded for battle, which will begin. I can't remember. Maybe Diz can confirm this. Were the jurors, the prospective jurors, reporting at 10 tomorrow, or was it earlier than that? Anyway, it's 9 or 10 in the morning, and this is days after days. This whole process will take place. Tomorrow will be a bit of a circus because it's technically the start of trial, right? It is day one. It's technically the start of trial. So I guess. Once that process begins, there is a little less curiosity, perhaps, and we'll see things kind of calm down. That'll be when that lull comes along that I mentioned.
Yeah. But you said there's people doing live shots, right? They're doing live shots right now and right next to you. That's why we're hearing some bleed over, some time and some conversation.
That could be. And I also just changed my microphone to a different setting, so it probably cuts out more of the background noise. Are you hearing me all right now?
Yes, I hear much better now. Yeah.
Okay, good.
Much better rather than the live shot that was going.
Let me just go see if I can get somebody over here. Let's start going through some of the stuff that came out today, and see how shocked we are.
And let's welcome spell checker. Okay, a new member. Welcome spell checker.
Spell checker. Okay.
That's me. I need not so much as me, a spell checker. Anyone who knows me knows that my nails, if I type a B, it hits the G or the H. So you learn to decipher what I'm typing by looking at your keyboard. My keystroking abilities are not perfecto.
Yes, I blame the nails. Okay, let's see. Where did you want to begin? We got a few options here. Okay, well, let me see what I can grab here. I'm going to build. Let's build. Okay. This was not even a filing, but I think it's interesting in and of itself. This is the Mark Betterow letter. He's very good at writing letters. I'm not sure what else he does because he doesn't seem to file motions, and I don't know why not. Do you know why not? Oh, there goes some paperwork. It's always windy here. It is always windy. So why do you think he's not filing a motion? This is basically
okay.
This is basically a notice to Robert Cosgrove, a letter, an email that says, hey, you guys, Rule 14 says the prosecution has to deliver A, B, C, and D. That's the discovery rules, right? And so he goes into some great detail about what they should be providing, which he thinks impacts his client, Aidan Carney. Why not? He's an attorney of record in the Aidan Carney case. He was denied pro hac vice in the Karen Reed case. But why doesn't he just file a motion?
Because you get a number of bites at the apple. And with this, you also get a bite at the media, okay? Because we're going to talk about this later on, or maybe we'll talk about it in whole now. But I think people want to hear about the motions in the Karen Reed case. He has laid out all sorts of theories and all sorts of facts that really impact the case against Aidan Carney in the defense's view in a very poor way. And so it's such that the witnesses' testimony have doubt such that this case should be against Aidan Carney should be dismissed. Now, if you file it in court once, you'll lose it. But if you file it here as a letter, we talk about it. We're going to talk about it again. We'll talk about it some more. Then there'll be a follow-up letter. We'll talk about it some more. And you get a lot of bites at the apple before you get to actually file a motion where a judge, as we've seen, quite frankly, in this county, not so much as Stoughton. Stoughton has been a little bit different, but a judge in this county gets to deny, right? So why have that? Why have the X come right through it? And I'm not sure the X should go through it, but I think that it's a sophisticated strategy. I certainly can't wait for him to argue something in court in this case. Although the best thing that could happen is it gets dismissed before it ever goes to trial. I mean, one of the things I was thinking about today, for instance, with the ruling that we're going to talk about, which is the third-party culpability, if Colin Albert is not going to be allowed by the defense to be one of their suspects, and therefore the prosecution, he's tangential to the prosecution's case, why should Aidan Carney be charged with intimidation of a witness? All right, but we can
at least as to that witness. Yeah, you're right.
Yeah, right.
I guess supposedly it still leaves Chris Albert on the mix and everybody else, the McCarthy, McCabe, Jen McCabe, Brian Higgins, all of those folks. But here's my concern with this. I appreciate the effort. It's well written. It's a lovely letter. But in terms of the legal significance, I mean, if I'm getting this, if I'm Robert Cosgrove, and I'm getting this, I'm looking at it, I'm going, this is very good. Here's what I think of your letter, sir. It doesn't mean anything to me, and it doesn't mean anything legally. So, but if you're just trying to pander to the public, okay, fine. I guess that's mission accomplished. But
I have to turn off my Alexa. Would you excuse me for 1 second?
please turn off your Alexa.
Alexa, dismiss.
I may be
The
arrested.
thing about it is, Alexa is on. You want to know how AI is saying Alexa's on silent? The red button is pushed, and yet it is has a little Kodak black going on. I don't know why that is. Just give me a second. I got kind of pull myself over here.
Trust me, Alexa is never off. If you know what I mean. Alexa is always listening in. So I'm going to get rid of this letter. I wish I could do an electronic tear up of it as I just did the manual version, because it's I don't understand. What's the end game? Because the letter doesn't mean squat. So
well, legally, but I think in the public eye it does. And also,
so what? I mean, again, so what? You think ultimately, if there's a jury being impaneled on the Aiden Carney charges, that they're going to think about, remember that, care about that letter? I don't think so.
No, but you kind of you start putting the DA on their heels, and this is when you start now. You start now. I think it's a psychological game, and you simply start now. And what if they can't comply with this in the future? And then you can say, aha, we've asked you, and we asked you again, and we asked you again, and we asked you for 7 times again.
Yeah. This to me is what you have when the old phrase is, if you can't negotiate, you litigate. Well, that's the kind of letter you're drafting when you're trying to negotiate a deal. Once you get to the beyond that and you're litigating, just put it in a motion or don't bother me. Okay, now I want
to find more about this Miss Peter. All right.
Okay. Well, I've gotten rid of the letter, but go ahead.
Okay, you got rid of the letter, and he's asking for specific conversations because she's saying that she is cooperating with the police. Well, he wants to know what's the cooperation, okay, with the Commonwealth. Why, if she's not, on the main portion of the list, why is she cooperating? Why haven't you told us? Why don't you give us everything? Why don't you give us what you have? And they're saying you have discoverable material about her, but we don't have any discoverable material. And then when we do find out Ms. Peters' own text messages it's redacted, confirmed that she leveraged her direct access to Mr. Mello and the Massachusetts State Police to help the Commonwealth's prosecution. We have a lot of redactions, so we don't know anything. Doesn't that pique your interest as to who she is and what she has?
Yeah, it is kind of interesting. I mean, for what it's worth, on a just a curiosity level, not on a legal level, because until it gets in front of somebody important like a judge, I don't care. I even tried the what's redacted game to see if I could figure out what was. It's kind of unclear. I couldn't really come up with much. I just got a note, by the way, from Tom CPU. Again, we've been talking about getting him on. Yeah. I'll try and continue to conversation with him while we're on the air and tell him we're on, but he is not here physically. He's in the area. That's all I know. So if we can get him to join us, we can do that. Yeah,
we've been trying to do that. He was gracious enough to allow us to use a lot of his, a lot of his video coming into the courthouse. And after he did that, by the way, I did make a donation on behalf of Justice Served TV to him, because I feel that, that's a lot of work and a lot of money that he's probably spending. We know what it's like to do that.
Yep. So we definitely appreciate that. So
by the way, while we're on the air,
yes.
There's a new motion. There's a new motion while we're on the air.
Well, since I sat down here, there's another one?
Yes.
What is it? What is it?
It's when you'd like to know. Okay, Commonwealth's, and of course it's from the Commonwealth, renewed motion in limine to exclude expert testimony of Garrett Wing. All right, we'll try to pull that up. Okay.
Okay.
All right.
And I guess they don't take no for an answer.
All right. So before you started discussing what we have, I just want to tell you there's another new kid on the block.
Okay, and remind everybody, including me, this is the expert on. What is this the expert on? The biomechanics? I can't remember.
No. This is the dog bite, the defense dog bite.
The defense dog bite. Well, that's, you mean in addition to Dr. Russell? There's another.
No, yeah, to rebut the guy from Florida. The guy who.
Yes.
Yes, you know who I'm speaking about.
Yeah, but I'm trying to remember the paperwork for that particular expert, and it escapes me at the moment. So
that's all right.
Well, that's being figured out.
Our viewers will tell us, right? Our viewers would tell us. But that was just filed. We don't even have it up on our drive yet. We will have it up on our drive. But that's a new motion that just came in, Michael. So there you go. Okay.
Well, that's all working its way through the system. Let's look at the third party mess. Okay. This is the memorandum of decision and order for the motion in limine to preclude. Who is it? Third party culprit defense.
Yes. The Saudi defense.
I'm trying to move it up here a little bit so we can see.
This
one is, and she'll address each one. This is allowed in part and denied in part. And so we're talking about, remember, in trial 1, these 3 names were identified, and in trial 2, they were repeated in pretrial motions by Attorney Yannetti. It is the 2 Bryans, right?
Right. Brian Albert
and Brian Higgins.
Brian Higgins.
And the Colin Albert person who apparently doesn't exist. That seems to be the thrust of the court's decision here. So the court broke it down into bodies, the 2 Bryans and Colin.
Mm-hmm.
And when I first heard this, I said, well, she must be focusing on the lack of evidence, questionable evidence as to whether.
Oh, Michael just froze. We can see the documents, although the documents have just frozen too. But Michael, you're frozen. I mean, what did the stand out against Elon Musk? Is that affecting our Starlink? You froze. I said, is the standout for against Elon Musk affecting our mini Starlink that we have there?
I'm that's right. Good thing I'm not driving a Tesla. I think it's anytime it's overcast, it's just not as nice as you would like. So bear with us if that happens again. Anyway, so motive, intent, right, as to this particular individual is a tougher thing to prove because there is no evidence that Colin Albert was at 34 Fairview when the defense, that's right, when the defendant and Mr. O'Keefe was at the home. That's the bottom line. So for her, it was a clean and easy decision to make. Now, I would assume if there is evidence that arises during the trial that he was in fact there, that this may get revisited. It'll certainly be a request made by the defense.
Of course, but you know, last week you asked me, what do I think about the motion, the Commonwealth's motion to preclude the third-party defense? And I said, I think the defense is hanging on in Judge Beverly Cannoni's mind by a straw, right? I think they're dangling by a thread. I think
yes,
is what I actually said. And this opinion is dangling by a thread. And to making account notes said Judge Beverly Cannoni continuing to protect the Commonwealth. That's an interesting play.
Commonwealth. See what she did there?
Commonwealth, yeah, the Commonwealth, yeah. Interesting play on words, right? Wow, you know. So there we have it. And even the decision. Well, you have that decision. I mean, we thought when Dr. Marie Russell was a close call, that was something. This, I think, is something even closer than a close call.
Yeah, what is that? Barely sufficient? Is that it? Is that
right.
How it's described? Defendant's proffer is barely sufficient. And she's basically saying, if I don't see what I like, it's not even going to be that anymore.
Yeah, she's saying a trial, right? A trial, you know. And by the way, you can't even mention it. Guess what? You can't even.
Yeah, at openings, In
openings, you can't mention it in jury selection. You can't even mention it. So, what do you think about that? I mean, they can't mention it. Then they cannot not bring it up until they start their case, right? So, how do you cross-examine if you're not pointing to that person on cross-examination?
You have to be very vague about it, and that's unfortunate. But the only hope for the defense is that during the course of the trial they can get as specific as they need to, and then they can pound away on the closing argument about it. But you know, it would be nice. It certainly would be nice to be able to dangle that out there for these jurors so that they're looking for it. But can't do it.
Yeah, and I would note that the ruling. That the defense did file last week a supplemental motion of theirs to explain further how the third-party culprit or some other dude did it, as we call it, the Saudi defense, played into this. And if you recall, ladies and gentlemen, and everybody else watching, because I don't assume anybody watching is a lady or a gentle person, there's a Supreme Court decision that says you have to point to a specific person to get the benefit of the some other dude did it defense, as opposed to proof beyond a reasonable doubt defense that somebody else could have done it. It's not a specific charge, right? Some other dude did it defense is a specific charge, but you have to point to a specific person. So that unless they pointed to a specific person and had enough circumstantial evidence to get past that threshold, they don't even get to talk to it before a jury. Now she's saying, hey, depending on what happens, I may limit you even in your case. And then again, you may ask for a charge and you may not get it.
Yeah. She's definitely not promising anything. In fact, if you believe her, she's going out of her way just to give you just a crumb of hope. Right.
Right. It's unbelievable. Let's answer a couple questions before we go on. We have a bunch of questions here, Michael. One is actually to me from Tara Ellis. Linda, your career has been so fascinating to me. Thank you. I thought for sure you'd have already written a book. I saw that you and your husband have, but not a biography yet, or am I mistaken? No, we have 2 novels that we wrote, and then I never got to the third one, which was about a third of the way done. And of course, my husband's written books about his career, including the last one about a year ago, American Autopsy, dealing with about phony defenses, especially when people of color are arrested by police officers. So, and how he started out the medical examiner's office. But no, I have not written any books about my career, and I hope to be doing my career for a lot longer. I do have an active law practice, and clients tend not to like when they think you're going to talk about them.
Or when they think you're done.
or they think you're done. Then there's no client. Yeah, thank you. Micah, based on today's ruling, should the defense file another motion to recuse? Her bias was leaking through all of these motions, and we haven't gotten to them. We've just gotten to this one. Michael, what do you think?
If you like just burning paper and time, knock yourself out, but it will go nowhere. It will not be reconsidered. So, if you wanted to form another basis for an appellate paragraph or 2 in your brief, knock yourself out. But to me, you got better things to do with your time.
So Micah follows up with, and Micah has one of our mugs, right?
That's right.
Has this one, but I have the black inside. Micah has the green inside. So the state doesn't have to prove motive on Karen, but the defense does. Right. The state never has to prove. The defense doesn't have to prove anything. They have no burden of proof. But that doesn't mean the jurors don't assume that they assume it once you have a defense. That's what happens.
Yeah. And the thing is, human nature is everybody wants to know the motive. Everybody wants to know why somebody does something. But it's not an element of any crime. And obviously, as you suggest, it's not an element of any defense either. So if you can prove to a jury, as the defense suggests here, that there is a reason for a fight having taken place that ultimately led to Officer John O'Keefe's death, something other than Karen Reed, then great, it helps your defense, but nothing you have to prove.
Right. So shall we continue on with this? If I would say, well, let me just say one thing. Being a defense attorney, high-profile cases, you expect all this. You expect judges to cut you off at the knees. You expect them to try to do that. That's the norm. Most of you watching, it's really surprising to you that you don't think this happens in almost all cases, because you've seen maybe YSL and a judge come to the rescue, and you've watched the Alec Baldwin where there was severe misconduct by a prosecutor and the judge came to the rescue. Guess what? Judges generally don't come to the rescue of the defense or the defense attorney. They just do not.
Yeah, that is true. Before we get to what I think is one of the bigger decisions of the day, and I'll call that the Easter decision, even though we're not quite to Easter yet. Yep. Let's look at the order regarding the jurors, because I find this interesting and it's a little extreme, I think,
to say the least.
Yeah, let me see if I can.
Michael, while you're pulling it up, you're looking at it. So you see me passing on the street. how do you describe me without telling anything that could be an identifying?
You know,
This is a good. This is a good question to train people how to testify.
I mean,
Describe me without saying anything that tells anybody
about your
who I am or what
specific
I am.
characteristics. Other
Right.
than saying a woman, what else? What else can I say?
You made an assumption.
I did. Yep. If I were in court watching a jury, as I've done bazillions of times, either as an attorney or as a correspondent or an observer, I always would give age range, ethnicity as best could be determined, and gender as best could be determined. That would usually be about it. Sometimes if there's a woman in the Daniel Penny case, older woman that wore a fedora every day. That was unusual. That was unique. And so I would comment on that. Based on this order, I'm not so sure you get to do that, right?
Right.
I'm not sure you get to do anything.
Well, and the other thing is when jurors are deliberating, what do you say? Was the jury dressed up today? Now, if I ask you, was the jury dressed up today? Does that lead to some specific identifying characteristics?
I would say no. I'll let you get away with that.
You let me get away with
because
that.
How would you identify anybody just because they're dressed up?
Well, I don't know. Well, they can't wear pins or no. They came in wearing a tie. They came in wearing a tie that said "Go Celtics."
Okay. If I said, well, first of all, I guess you could probably get away with that here in this part of the world. But if I said it was the juror wearing the Go Celtics pin, and it was only one person that I think would be a specific reference that you would not be allowed under this order.
This is a terrible order.
It's horrible. So let's look at some of what makes it so horrible. And some of the screens I'm looking at here are so small. I'm sorry. They got the court reporter, right? Will be responsible for the entire trial record. This is all very normal stuff. That's why I didn't highlight it. And then number 2, in the highlighting there, the court concludes that the fear expressed by the juror, and she's referencing a juror from trial number 1. Remember, a juror said, "I'm frightened for my life." So based on that, and really that alone, the judge has decided to impound the clerk's list of jurors for the county, and that would be everybody, whether they're here or not, whether they're picked or not, whether they're in the pool or not, everybody. That's extreme. I could see those that are collected as prospective jurors and obviously those that become jurors. But to go beyond that seems to be a little extreme to me. Thoughts?
Yeah, I agree with you. I think that absolutely, we've never seen anything like it. And this is taking what the jurors said and turning it on their head, because one of the jurors who provided an affidavit said they felt intimidated by the Alberts, right? Family sitting in the front row, glaring at them. That's where the intimidation and the fear came in. So now we have, now we're turning that type of statement by a juror on its head and saying, therefore, the jurors are scared. And that's not to mean that the jurors should be identified. I've had cases where the jurors aren't identified, but people call up and say, but you can still say, juror number 1 appears to be Caucasian, appears to be in his 40s, appears to be tall enough to play basketball for the Celtics. I'm torn on the Celtics because they just sold for $6 billion,
Yeah. So look at this final note here. Okay. Spectators and media are prohibited from attempting to provide specific identifying information of jurors or potential jurors. What's to say? Oh, to the public. Yes. Including physical descriptions of the jurors. Again, other than what you just mentioned, I mean, I would never even say something like tall, short, large, small, skin. I would never go into those kind of physical descriptions. They were more generic than that even. So I don't know. I would love to find out what those specific identifying features might be that are allowed, if at all, if any of them. Why can't I just say there are 5 men, 7 women, right?
Right.
And 2 of them are African American, 1 appears to be Asian. I mean, to me,
what's wrong with that?
What is wrong with that?
Nothing. That's how we normally do it, and then people make assumptions on it, and what's wrong. And the scary thing is, usually, of course, you go into a courtroom, even if they don't allow you to show the jurors, and the jurors aren't sketched. People go into courtrooms and they see the jurors, right? And they're about, oh, there's there's a woman who was making faces. There was a guy who was like falling asleep. They talk about it. What now? People that come into the courtroom and see the jurors, they're not allowed to go outside and like to go have lunch with their best friend and say, hey, I was in the courtroom and this is what I saw. Blah. They can't do that. How are you going to force it?
That's the other thing. It's a joke. It's a hollow threat. Obviously the media is going to be targeted, right? If there's any reporting done suggesting that these are specific details. I am curious, and as I said before, normally the prospective jurors would walk right past me here out these double doors across the street. That's pretty wide open. That's a pretty open field, right? So are they going to do anything at all to protect those in that prospective panel? We think about 100 of that first 150 or so are going to be interviewed, questioned that day. Tomorrow, 50 of them, the last 50, however they number them, the last 50 are going to be excused to go home for the day, and then they'll come back the next day as necessary. So that means you got 100 bodies, right, that are identified as prospective jurors walking across the street up and into the courthouse. I mean,
are they going to go in the back door after they?
Well, that was my first question. I don't know. I have not heard that they're going to put that kind of special control on them. We know that once they're selected, yes, they'll come and go out of the back door.
Is there any
the actual selection process? Hard to tell. What was that?
Is there anything being built when you turn around there? No. Like, how when you have the Oscar awards and you see the night before they're building like a 10, or down the road from me, Kim Kardashian was building her what's her store dealing with women's wear, right? Skims, right?
Her whatever those are called. Yeah.
And the night before there was like, overhangs being built into the street where people could come in and all. Is there anything like that when you turn around? Do you see anything like that?
No, but this is the front of the courthouse, so other than the stanchions you see along the street, I'll take another look along the back. There was nothing there when I came around to get set up. I'll look in the back and see if there's anything there. We know, and I've mentioned for the Arbery case in Brunswick, Georgia, they had like a tunnel that they had created, a canopy out of the back door of the courthouse to get the jurors from there onto the vans. So they never really were exposed to anything, drones or photographers or human beings. I don't expect they're going to do that here, but I'm going to double check when we're done and I'm wrapping it up.
Well, let me ask you one other thing, since you're standing in front of the Dedham courthouse, where hardly anybody else is today, because they're going to be there when the cameras are there. We're cameras too, but I want to get the background of this. There's a 500-yard, if I recall, zone, protective zone, right? Buffer zone, as they call it there.
500 feet. So it's 500
feet. I'm sorry, 500 feet buffer zone. Are you in it right now?
Oh gosh, I'm smack in the middle of it. Yeah, I'm even in the 200-foot zone from trial number 1. So yeah, that there's no way, and I'm not sure how they're going to handle. There normally are people that queue up here, the press, because it's covered, it's elevated a little bit. It gives you a nice shot of the courthouse behind, but I don't know if they're going to allow that tomorrow. We'll find out, because people are going to be scrambling for locations, right? And this one has been a pretty good one. For usually a couple of outlets get in here. I weasel my way in as well, but I don't know if that's going to be allowed tomorrow, especially if it's in proximity to these prospective jurors that are coming and going.
Well, then, is there any indication that they're setting up cones or stanchions to do type of crime scene, like crime scene tape, or something like that prevents people from coming in, things that are movable that are going to be taken away?
I don't know if you can see or not. I'll try and twist over that way a little bit. But yeah, it's so hard to see. But along the stanchions and down to the corner, they've got crime scene tape that is wound through the stanchions. So it's really just to make it more visible that the stanchions are there. They're not really any different than they normally are, but they've added the yellow tape to make them more obvious. So
now the funny thing about that is the reason I didn't see it. So I just said crime scene tape because the one thing that was missing from the John O'Keefe death scene was the crime scene. Take
I can
that
tell you
around the stanchions or around police cars.
There's far more protection here than there was at that crime scene. Yes.
Brooklyn has a question. Are there any people against Karen Read outside the court tonight?
Yeah. Nobody today. I mean, it's like I said, it's virtually empty. I would expect tomorrow both sides will be out in full force.
Yeah. Okay.
And I'm looking forward to talking to some of those folks.
Both
because
of them, right?
every time I've been here, half dozen times now, nobody is here that is pro-prosecution. But I expect they will be tomorrow. So I'm looking forward to talking to those folks and get their take. As long as it's something substantive, I've talked about this before. I don't want to hear just personal attacks on anybody because they think differently. Give me some substance. What evidence do you like? What are you thinking about? What do you think proves the prosecution's case? That's what I want to hear.
Yeah, somebody leveled a kind of a personal attack on me on Twitter today.
No.
Who was it? It was about the Sandra Birchmore case that they saw that my husband was in it. They thought that was great. And then they saw that you and I had appeared at me. They didn't level you. They're always going against me. I don't know what it is. I had appeared on the Will DeGlara show. And since I appeared on the show with what they called him a criminal, they said that now no longer can accept either of our opinions. I don't know what that has to do with anything.
Yeah, I'm sure you're crushed by that.
Just so crushed. You can go follow it on. You can go see it for yourself. I mean, I just said, I don't know what I said, but I usually make some comment back on that because I think it's inappropriate to make this kind of comment. So I do have to make a comment about this, though. You see, here you go. Here's one for you. Samuel Stanley says, have you seen Sean Hoover, Georgia's top gang public defender, is prepping for another one of the cases with Fonnie Willis?
Oh my gosh.
Little baby, and to be indicted, another RICO on the way. And I did notice, by the way, there someone said there was a phone call being played where I think it was Little Baby said that there were 4 stamps on somebody's head or something like that. I don't remember the exact words. Don't hold me to it, but it's all over the internet. So
can't wait for that one.
Can't wait for another. I wonder if any of our lawyer friends will be in that one. Samuel, if you have more information about it, send it to our email, justiceservedtv@gmail.com. We'll take another look at it. I'm sure I would love to ask Ashley Merchant and Doug Weinstein about that. But there is one about you, Michael. Look at this. Kevin, Honky Brennan spell checker. Honky
Bill Hader's character, Herb Welsh from his. Okay. Oh, is that the guy that's
Saturday Night Live with the microphone?
Yeah.
I think that's a cute
I think that's
one.
who it is.
Yeah,
well, I've been called worse.
That's not calling that. That's a compliment. That's
is
really
that a compliment?
Cute.
Bill Hader is very talented. That guy, he's so
really
creative,
cute.
so funny, and the show where he was the killer, and amazing guy.
Bill Hader was a killer. I don't think. I think I missed it. No, but he's really cute. That's a compliment. That's really kind of cute. Thank you for that. That's really adorable compliment. Anyhow, yeah. So yeah, hopefully you get to talk to people, but you may be in. Where's the closest you can set up then?
Well, I won't know till tomorrow because, as you know, we don't have an official media credential. I always just act like we're good.
They didn't even answer us this time.
No, they didn't even on this time. No, but I always just act like I belong. And so far, the cops have not made a big deal out of it. But technically, I probably shouldn't be right here doing what I'm doing. So we'll see what the enforcement level looks like tomorrow. If I have to go this direction is the area that has not been extended. That's off to my right, screen left. This is the area that has been extended to the point that, as we learned from Scott McGinnis, it wipes out the area they used to stage in and kind of prep and gather. It puts it way past the street where the parties usually arrive. So it'll be very interesting. I'll do some wandering around, see where they really are, get a sense of where they're going to end up, because they're going to end up somewhere. They ain't going home.
Maybe you'll find out tomorrow by walking around where the parties are coming in, where the parties themselves
Well,
are
the parties,
coming.
I think, are still going to come in the same way. In fact, the gauntlet has already been created, and it's going to be a clear run for them. That's not going to change. But where the supporters can be, and again, it's supposedly only if you have, the accoutrement of supporting one side or the other. If you're like, me, I'm dressed neutrally. I don't have anything pink on. I don't know what the effect is.
Yeah, you may be able to be where you are. By the way, K Schmidt, gifted again. Thank you so much for this. Let me show this 5 Justice Serve TV memberships.
Thank you, Kay.
very much. Thank you, Kay. Very, very nice of you. So you may end up being able to be there because you're not
Because I'm not
a supporter one way or
yeah,
another.
exactly. And I get the feeling that even if you're a supporter, but you're not dressed like a supporter, if that makes sense, you perhaps can be on the sidewalk right behind me as well. So
Wow.
2 questions: whether I'm going to be able to be in that area generally, or where I can set up for what we do. That's going to be probably a little further away.
Yeah. Now I'm going to put up a question on Michael Easter. I think we should talk about that.
Oh yeah, and I got that one queued up, I think.
Okay. All right. And Michael Easter. And let me put up the question, and we're not going to answer it yet. It's from Christina Marie. We'll just put it up. Do they have a chance, meaning the defense, for an interlocutory appeal for Easter? Is something like that possible? Thank you. All right. So why don't we discuss what happened today with regard to Michael Easter, and reminding everybody he is the crime analyst, not a crime analyst, the crime expert, crime procedures,
Former FBI dude.
Former FBI procedural, I'd say, how you investigate a case. The expert that the defense wanted to present, very common in many jurisdictions, and he wanted to say that not only was the investigation done improperly and in violation of most police procedures, but it was also in violation of police procedures both of Canton and of the Massachusetts State Police. He wanted to be not only generic but specific, because he looked. Alan Jackson made a point that he looked at all the procedures to see, number one, I guess, whether or not first they're in conformity with the generic procedures as taught by the FBI and others, and secondly, whether what they did was in conformity with their own procedures. And guess what happened?
Well, denied. Here's the memorandum, decision, and order on the Commonwealth's motion in limine to exclude Michael Easter. And I guess it's possible he is resurrected, but highly unlikely. Let me hit some of the high points here of this detailed and flawed analysis, in my opinion.
Yes, flawed, and let's put it on. We put it on the line, by the way. And if you like that we're saying that, you can hit the like button on Justice Serve TV. And if you think that we're aligned with some criminal and you don't like we're saying that, you're not going to hit the like button. But please hit that like button.
Let me share this before we dive into this a little bit more.
Okay.
We have comments, of course, and somebody, and I think it was, I want to say Chris. I'm not 100% sure on that. Sorry, Chris, if it's not Chris. But they were calling me out. They said, now that Easter has been denied, Mike called me Mike. You said you would then agree that Judge Canone is biased, and you need to admit that and be true to your word. Okay.
You did say that.
I did say that, and here's perfect proof of it. In fact, I'd like to find out, Judge Canone, could you come on down here? Come and explain this to me right here. See if she'll come down and give us some explanation as to how she could possibly decide that you can't attack the credibility of the investigation. Because why? Because she didn't find a Massachusetts case, and we saw her queuing this up when they were arguing the motion. Do you have a state? Do you have a Massachusetts case? And I think the response at the time was, "I'm looking for it. There's certainly some federal cases," and she made it clear that she was almost like she knew there wasn't any Massachusetts case.
Right.
So what she now says is the court cannot find, nor has the defense counsel cited, one Massachusetts case where an expert was permitted to opine on the general competency of a police investigation. The lack of authority suggests that I can't read my title, that during all of the jury trials where the defense has been inadequate police investigations based on Bowden, we'll talk about Bowden in a second, expert testimony has not been needed for the jury to be able to evaluate the reliability. And what she's saying is, she's almost saying it's a layperson analysis here. Remember, you only need expert testimony where it is outside the purview of a normal person, a lay person. And she's making it sound like, well, there's no Massachusetts case because you don't need an expert for that. The Commonwealth's case and whether any failure to investigate steps are sufficient to create a reasonable doubt of the defendant's guilt. Again, you don't need an expert for that, is what she's saying. And because there's no Massachusetts case on point, you don't get to have one. So what does that leave them to do? Of course, they're going to be cross-examining all of these cops about using red Solo cups, about using a leaf blower. Where is that in the manual? That's the cross-examination is going to have to fill this hole.
Yeah, and she says, through zealous cross-examination of police witnesses, the defendant can cast doubt on the reliability of the investigation by demonstrating how it differed from standard practices and procedures, and can raise the issue of potential bias by police action or inaction, as counsel did effectively during the first trial. So there you go with Neil Rockhines. Atta girl, atta boy, atta good defense lawyer. You're so good in what you do. You don't need to have an expert do what you do. By the way, how are you going to say it different from standard police procedures? Because they're just going to lie. They're going to say, yeah, this is how we do it.
Well, I have to admit, in that case, common sense will rule. The jurors will go, you're telling me that's normal? Not to rope. I mean, people have seen enough cop shows. Simple things like cordoning off a crime scene, that's kind of law enforcement 101. Gathering evidence properly, marking the evidence with tags, having evidentiary a chain of custody. All of those things people know about. And I don't care how many times you say it's normal and it's the way it should be done. People on the jury are not going to say, oh, yeah, you're right. That's great. I'm sure you did a fine job. So let me just say officially, as a result of this, I believe Judge Cannone is biased.
There you go.
I've gone over the line.
There you go. Now, to remind everybody what the Bowden defense is, okay? Let me just quote it, and it's actually in the opinion, because she quotes it because it's important. The defendant may present evidence that certain tests were not conducted, that certain police procedures were not followed, or that certain information known to the police about another suspect was not investigated, in circumstances in which it is reasonable to expect that the police should have conducted such tests, followed such procedures, or investigated such information. That's the Bowden defense, okay?
Okay.
So, but how do you, without expert testimony, really satisfy the last prong? And this is where I see Hank Brennan going, that there have to be circumstances in which it was reasonable to expect the police should have conducted this test procedures or investigated the information. They're going to say, well, it was snowing. We didn't expect this massive snowstorm. We had no way to do it. So we took our investigative judgment and we borrowed what we thought would be clean cups from somebody. That's why we used red Solo cups. Okay. That's why we use a leaf blower, because we had to get to John O'Keefe and get to what we thought was the evidence without blowing the evidence away. How do you do that? Because that's, I see Hank Brennan going there.
That's it. You've got to justify it. I think it's one of those situations where if you say it with enough conviction, you're just hoping people believe it, because what else you got? One of the things that makes me wonder is this the Keystone Cops here? You have units called to a crime scene, and at a certain point, there's a either dead or dying victim, right? And you don't have a CSI type mini, kit with every single cruiser. I don't mean the full-blown CSI team, but just a simple kit that has collection, it has gloves, has bags. It just makes it sound like what a Mickey Mouse operation this is, with all due respect to Mickey Mouse.
Yeah, the defendant is undoubtedly permitted to pursue a Bowden defense, and the court will give the Bowden jury instruction if requested. However, jurors are perfectly qualified to evaluate the adequacy of the police investigation in this case without the assistance of an expert. So that's actually a good thing for the defense, that statement there.
I agree.
She's saying it's so fucked up. That's a legal term, ladies and gentlemen. This is a show not for children. That you don't need an expert here. I'm not going to prolong this with an expert and muddy the waters, because everyone can see this is a screwed up investigation, right? So in that regard, she says she's going to give the Bowden, she's going to give it. If you show it, she's going to give it.
Yeah, I think there's going to be plenty to justify it. And so in an odd, weird, twisted kind of way, she is slapping them down, but kind of giving them an attaboy that they've got enough to work with, right? You know,
Right.
it's a weird situation. I think she needed that to justify granting the motion, or as they say here in Massachusetts, allowing the motion.
It's the most ridiculous thing I've ever heard, that you can't have an expert to say that
Of
this
course.
procedure is, because but the interesting thing will be is the prosecution opens the door to that and goes on closing and says, and you never heard any police expert come up here and say that that investigation was flawed. What do you do then? Is that a mistrial?
Yeah.
Yeah, open that door. I mean, I think Brennan will be very careful, but things slip out. And that leads us to Christina Marie's question. Do they have a chance for an interlocutory appeal for Easter? Is something like that possible? Thank you.
Yeah, they could take, in California, we call it an extraordinary writ. I'm not sure what the terminology here in Mass happens to be, but you're basically saying we aren't going to wait till the end of the trial. We aren't going to throw this into our appeal. We need things looked at right now. We need a decision right now. And so there's a mechanism to do it, I'm sure.
Yeah. There is, because we did that in Hernandez. We took it to something to the Supreme Judicial Court, and we were denied, but we took it because we felt we needed to. There is a mechanism, but it's very, very hard.
Oh yeah,
very hard. They did something like that in California in ASAP Rocky with the jury. Remember when all the jurors, when they didn't have one African American or Black person come up in the jury veneer, and they took an extraordinary writ there, and we're denied.
Denied. In fact, I think. Joe Tacopina asked the court to stay proceedings while they took that writ up, and of course Judge Arnold said denied for that as well. And they denied it at the appellate level pretty darn quickly, so it didn't really gum up the works. So.
Yeah. On the last point we just made, Samuel Stanley said it would be burden shifting at closing, so how wouldn't it be a mistrial? I agree. I think that I don't think he would do that. What he will say is he'll say, you'll never heard one police officer from that stand say that the investigative procedures were wrong. That's what he'll say. And that's how he'll get around it. That's what he'll say. That's a good question, Samuel. Thank you for that question. Now, just let me backtrack one. There's a question we have here from Samuel Stanley again, in terms of why doesn't Justice Serve TV file a motion to intervene on this juror issue, as it's not narrowly tailored and impedes on the First Amendment of freedom of press? Well, very interesting, because if we had been given press credentials, we may have.
We're just folks. Yeah.
Yeah.
And then, I think it would be a great test to just start trickling information out.
Right.
Wait for somebody to enforce this vague rule, and then you got something to argue about. You got to push, and you got to.
Let me tell you, somebody. Yeah, and if somebody decides to do that, I'm going to represent right now. I will try to make a representation pro vice to help a Massachusetts counsel come in and defend that person. Okay. Just so you know, because it's so.
Okay, I'll call you later.
That's now my first client could be my streaming partner, Michael O'Brien. We have a lot of questions on that, by the way. Louise Powell, is it ridiculous, Linda, about the expert not being allowed? Have you come across that before? It is absolutely ridiculous. I have seen judges deny experts because they feel, usually it's when you want two experts on the same issue, and they really just don't. It's not that they're intertwining, but they overlap. Okay, it's not when you're just using one expert, and it was raised in the first trial by the Commonwealth that the police did everything right, so they're trying to prevent that. So yeah,
the way around it is very clear. She said it doesn't require expert testimony, and you don't have a Massachusetts case that says it does. So too bad.
Yeah. What do we appeal on Hernandez? We wanted the issue of the Supreme Judicial Court to rule on the issue of the firearm tool mark identification, to give more clarity and not just rely on their ballistics opinion, which said ballistics was not a science. We thought that was a great start, but we thought that this was a good case for them to rule on that. And since they were so forward thinking, believe it or not, the Massachusetts Judicial Court, the Supreme Court there, the top court, is forward thinking usually on forensic issues, but they said no. And, it turns out that they didn't need to reach it because we had a not guilty on that verdict. So that's what we had taken a writ up on that. Okay. On that one. And then Scott, hi, Scott, you're around. Hi, Scott. Thank you for joining us. I have to correct an error from my previous interview. Okay. We enjoy people that own up to what they have said. Like Michael Bryant just said, he believes now Judge Cannoni is biased. I said Lieutenant Gallagher from CPD was the leaf blower user. It was actually Sergeant Good from CPD. I confused the two officers. Thank you, Scott, for
I'll allow it.
Letting us know that. Are you around? Are you in the area, Scott?
He had another comment. I love this. Turtle Boy may be the first one to test the ban.
Well, I'm here. I mean, I
gas.
made a representation that I will join if people have to want you.
That would be very interesting. Look at this.
Join local council, because I feel very strongly about that.
Scott is saying the only problem for him is bail could be revoked. That's very interesting, because how in the world would violating that order rise to the level necessary to revoke his bail? I'm not saying it couldn't be attempted or used, but can you imagine that? To just say one of the jurors had on a flowered blouse today. I guess that violates the order, right?
Well, identifying, well, maybe or maybe not. If they said it was a Gucci flowered blouse.
Oh, well, then they know you were on the jury. So that would be really weird.
I think the issue of having clothes clothes can't be an identifying feature, because
I don't know. What does that mean then? What does specific descriptive items mean? Your
hair color, your height, your weight, your eye color, maybe your lips, whether you have one arm or not,
That might be, the one-armed man.
The one-armed man from The Fugitive. Those of you who are old enough to remember that. Was he one-armed? He was one-armed, right?
He was, the one-armed man.
Paige wants to know if you'll be in the courtroom for jury selection.
I don't think so, but I'm going to try. I don't know which courtroom. It's obviously not going to be in the tiny one, but there are two others. One is really big, and I don't know what they're doing in terms of shepherding the people in and out, but I'll be knocking on the door.
Yeah, he's there. I mean, as everyone knows, we are one of the streaming networks. We've been there. This is what, your fourth trip in?
This is the fifth now. Yeah.
Fifth trip in. And when very few people were there, we've been covering it. As people who have been on our show know, that we made a commitment to this case to cover it. Way back when, it came from when we were at Law and Crime, and we were covering it there. And we left Law and Crime, we started covering it. So it's just such a fascinating case from a legal standpoint. And I was thinking about this, because somebody in New York I was talking to never heard of the case, okay? Because we're in New York, I guess. All right.
Yeah.
But thinking about it, this case, the reason why and the question was, why is it so big? And I think it's so big is something that you hit on. This case is not really about Karen Reed. This case is about, she's the vehicle for the complete frustration people have there with what they see as a system that is not fair, policing that is not fair. They see that it's almost like, if you want to put it in political terms, the election, right, that we had, right, that people feel that they're forgotten, lost, downtrodden, are going to vote for a certain candidate versus another candidate. That's kind of like, she is the vehicle for that frustration.
Yeah,
here.
A lot of people that see, there, but for the grace of God go I. That could be me in this scenario, based on what they believe the cops did or did not do. So, as I've said many times, she's the symptom, but the disease is far worse and widespread.
Now, Dizzy, I just had to tell you that somehow I deleted a question that I was supposed to ask, as I went to put it up on the screen to ask. So I apologize for whoever that is. I'm sure that my nails got I'm just going to blame my nails.
There you go.
I'm going to blame my nails for everything. So, but the Easter decision, Michael, I just, you saw it coming. You knew it was coming.
I really, that's why it was the tipping point for me, because I thought it was such an easy call that if it went the other way, as it did, there's got to be a reason. You have to really work hard to find a reason to deny that testimony, and the judge did.
Yeah, let me just.
And she won't come down. I asked, and she won't come down and explain it. So
I heard you say that. I heard you, right? So we've talked about the jurors. We talked about the fact that we mentioned in passing that the sidebars aren't going to be public either until after the trial ends.
That's not all that crazy. That's not, in my experience, that's not a big deal. We still waiting for sidebars in ASAP Rocky, aren't we?
Yeah, we are. As a matter of fact,
where are those?
As you know, there's one sidebar that I'm particularly interested in,
Mhm.
apparently, because Joe Tacopina, when we interviewed him, said, "Oh, you're interested in this sidebar." So now I know which sidebar I was interested in, right? And that has to do with whether or not the prosecution was queried by the judge about whether they were going to go forward on Relly's testimony, ASAP Relly's testimony against ASAP Rocky, given the ethics of the issue, or some. We don't know the exact question, but it's somewhere around. It had to do with something about that, and then asked the second day. And I am, if that's still sealed, I think the answer to our question's there. So we've been waiting for that sidebar to be unsealed, and we are going to then ask, obviously, the Los Angeles District Attorney to be on the show to ask how do you continue to prosecute if that sidebar did exist. But you got to open up that sidebar. By the way, John Miller says you know what's redacted. You do? Okay. What's redacted? Tell us. Is star the
In which document? In which document?
I think it would be the redacted documents came from Aiden's case, Aiden Carney's case.
Oh, okay.
Right.
Not the Bedero letter, but the
Bedero letter. Yes, the Bedero letter. It's actually it's Karen Reed's case docket number, but it's the Bedero letter that dealt with Aiden Carney, even though it's under Karen Reed's docket number, right?
Hills Bills, thanks for the shout out. Thanks for the heads up. Wouldn't that be funny if I yell again? I already yelled once, and I really think you yell enough, and the Stadies will come and find me. The Stadies are the troopers here. But wouldn't it be funny though if she came out and she was like just leaving for the day, and she came over and gave us a minute?
Yeah, I also read that in the new jury questionnaire is out, which would make sense that it's been done.
It's time.
I mean,
yeah.
Jury selection is tomorrow.
Is that public? Do we have a copy?
We haven't seen a copy of it. So if anybody has it, the new one, not the one that we talked to Richard Gabriel about last week, because they made some changes in it. We certainly would like to see it. Certainly before tomorrow, right? That
would be good. It doesn't surprise me if they keep quiet until after the jury is impaneled, but So I was going to ask you this. Oh, the protective order, which is in the I'll call it the crossover case. This has to do with communications sought by Cosgrove for the benefit of Brennan. I'll put it that way, that were between Aiden Carney and Karen Reed. As I'm trying to remember the time period, but they had anything related to what might be interpreted as witness intimidation, right? And during that whole craziness that happened, was that 2 days ago? That was Friday, right? Was that Friday morning or Thursday morning? There was the judge.
No. Now I'm losing track.
I think it was Thursday. It
was Thursday, right? By the way, this says you can get the jury questionnaire from the clerk.
Oh, okay. Well, we'll see if we can wrangle that.
Get into the courthouse tomorrow at 8:00.
We'll see. Yeah, we'll see if that's possible. I mean, that wouldn't surprise me for them to impound or seal it until the jury's impaneled. I could see that, but we'll see. We'll see what they're doing or not doing. So the protective order was granted, right?
Yeah.
Meaning that information sought out of the phone or phones. Remember, they got 6 of Aiden Carney's phones. That material is protected. They put it in for a protective order, and even though Yannetti took no position on it. Remember, he said, we're staying out of this. It was granted. So Cosgrove is not going to get anything from those phones, which we think they've already seen. But anyway, not officially going to be turned over to the prosecution in either case.
Interesting. Now, do we know what time the jurors are reporting in tomorrow? Whether anything is going to be open for streaming, so we know what time should be streaming. I know you'll be there. But, we'd like to, if they're open and they're streaming something, we want to stream it to all of you who are hitting that like button right now. Remember that like button? Diz
says she has the order. Is that the order for the protective order? Is that the one? Because I didn't get it uploaded before I sat down. I mean, the guts of it are pretty simple. We know what was being asked for. We know they ain't getting it. But it does lead me into one thing we haven't done yet.
They said, she says Boston 20. Yeah, she's loaded into it. I'm going to look at it right now. She says Boston 25 has posted it.
Okay, good. If it's anything different than we just talked about, let me know.
Here's the protective order. Yeah, I got the protective order.
Okay, good.
Have you seen it or no? You haven't seen the protective order.
Are you asking me now?
Yes.
No, I've not, because it wasn't loaded by the time I sat down. So
Okay. It's a disc. Is there a way we can load it up for Michael to go through it? Because
I
it
can
has.
try and pull it from while I'm sitting here, but I'll need you to talk about something while I'm looking.
Yeah. So actually, because when we get down to a certain portion, this is the order on. It's labeled Order on Intervenor Aidan Carney's motion for protective order under Commonwealth versus Karen Reed. Okay. And it basically says there were submissions, and it says the motion is allowed in part. The intervener has raised significant concerns regarding confidentiality related to the Commonwealth's prosecution of Mr. Carney in another crossover case, specifically his concerns over law enforcement's use and or dissemination of data obtained by search warrant and extracted from Mr. Carney's cell phones. The court deemed intervener's concerns sufficient to warrant further court action, however, only as it pertains to data that is being produced per the court's March 20th, 2025 order in this case, and only as it relates to the above caption case. That's Karen Reed's case. The court acknowledges the other investigative materials of discovery beyond that covered by this order are already subject to the court's prior order concerning counsel's obligations. And the intervener, Carney, has also moved for an identical protective order in the pending case in which he is a defendant. That motion is not currently before this court. So, with regard to the data extracted from Mr. Carney's phones and produced per the court's March 2025 order, the data the court now orders, and you want to read the rest, Michael? You want me to do it? Because I could say, let me just say first, Mr. Brennan, did we misunderstand each other? Okay. Was there a misunderstanding? What about what I said? Well, here now there can be no misunderstanding. One.
So that tees up, I think, perhaps without tipping off where we're going with this, very important thing we do every Monday. We've been trying to do every Monday, but sometimes we don't quite get around to it. Do you know what I'm talking about there?
Right.
Let me see if I can find it. I'm going to present this to you.
Okay.
If you're just hold on.
And then we can read the rest.
Hold on. Okay, here, I think it's right here.
Battered flames, they charge with light. Eyes like fire, hearts alight. Drums of war beat through the night. Victory, oh, what a sight.
Attorney Brennan, I'm going to ask you to pause right there.
Raise souls in the storm. Raise your swords, no more tomorrow. Giant hearts in battles born. Legends forged and never torn.
All right, so there is our, I think, well-earned person of the week.
And that is Judge Adam.
Judge Sisiski.
Yeah, Judge Adam L. Sisiski, Associate Justice of the Superior Court. Let me say his name, Judge Adam L. Sisiski. And why? Because he ruled as follows. 1, all agents of the Commonwealth, including but not limited to any members of law enforcement agency or agent or contractor thereof, that could be Hank Brennan, contractor thereof, shall maintain the confidentiality of the data and shall not share, publish, disseminate, or otherwise disclose the data or any information concerning the data to anyone other than counsel of record for the Commonwealth in this matter or counsel of record for the defendant. Number 2, this protective order shall take effect when entered and shall remain in effect unless terminated by entry of court order. And number 3, any person who violates this order shall be in contempt of court. So ordered this 31st day of March 2025.
Amen.
Amen. Okay. And let me repeat. Did we misunderstand? I take full responsibility, Your Honor. I may have misunderstood. We misunderstood? Did we misunderstand? I thought that was one of the best lines holding Hank Brennan.
Maybe I misunderstood. Maybe I'm just that's my mistake. Yeah.
Okay. All right. Samuel Stanley has a question, and I'm just going to answer it because I see it pop up and because I'm so familiar with this kind of stuff. Have you seen there are 9 law students clerking for Karen Reed defense, according to Boston 25, including 5 from Boston College, 3 from Harvard University, and 1 from Northeastern? Doesn't surprise me because I've done the same thing in every single case I have. And we were at the Specter case in California. We had all law students. We actually got them credit for courses for being actually helping us. And a lot of them went on to be lawyers. Friends of ours on Twitter followed them. So yes, it's one of the things you always do as a team. You go to the local law schools and you try to get students that are in some of these programs, and you try to get them credit also to help you. And they get experience they've never gotten, and they've been in the courtroom. We also had that in Hernandez. They weren't allowed in the well, except that I had one exception. One lawsuit was allowed in the well because he was wearing the shirt I needed for my demonstration to do the demonstration. So the judge made an exception because if they don't have the law degree, they're not allowed in the well of the courtroom to sit with you.
Right. Yep. You got to work hard and get the your ticket before you can go into the well.
Yeah.
It means so much more when you can do it before you know that. When you don't know what it matters, it's no big deal. But once you get that ticket and can enter the well, that's when the fun begins.
Yep. Yeah. So I just saw that passing. I just want to tell you, it's a little thing that we do when we have high profile cases.
I was trying to reach out to. Do you guys have Tom CPU's contact info, because he's apparently hanging out and
waiting to come on.
Well, yeah, just reach out and see if he'd like to join while we've got some time here this evening.
By the way,
Candy can, if you can,
yeah. We as a group, we have gifted 5 Justice Served TV memberships also tonight to all of you. Thank you very much. Missy's going to reach out to him because he's around. And Scott, you may be near Tom CPU. Everyone near him. I know he talked about possibly trying to get on one day this week. We suggested Monday, and it was the question of whether he's around, and apparently he may be around. Larissa, right? I got it right. Harris, I have it right this time. Larissa, I only have an option for super sticker or super chat. We'll have to let somebody help. You can see that my nails can't even hit the right keystroke. So we'll let Dizzy or Missy help you on that, Larissa. Thank you very much, though. It's really great. They'll see what they can do and what it is. All right, so we had that. All right, we had.
I like the microphone, my brother that makes it. It's a great idea. It makes it interesting. Okay.
Interesting, yeah. Although Michael and I have a little thing. So he told me to get this certain mic. I got the same mic he said he got, but then we have the cubes.
No, you did not.
You gave me the link.
No, you did not. If you go to order the microphone, they have like 2 options. This would be option. This is option A. You see the size. There's option B, and now she has microphone. Now she has microphone envy. So that's you gotta get the right size microphone.
You sent me the wrong link. Was it purposeful, Michael Bryant, so that you go on the road and I can't because I don't even have a microphone that works?
Yeah, that's it.
Oh my goodness gracious!
Put some tape on there.
Oh.
All righty. What else have we got? Is there anything else we haven't covered that came across?
I'm looking because there was so much that we didn't even finish motions from last week, and one of them is still kind of interesting. Actually, a couple of them are, and that's the reciprocal discovery for the ARCA witnesses, right? And and the Commonwealth's motion to compel reciprocal discovery, but the judge apparently today said, and we don't have the actual order loaded up, but apparently the defense cannot mention that they were hired by the federal government and that they were independent, and they can't mention a federal investigation. I mean, if trials are a search for the truth, why not, Michael Bryant?
That's a very good question. And I'm trying to remember. I think they certainly talked about it in the first trial. And is this suggesting they can't even question about it?
Yeah, that's what it's. I haven't seen the order, but they cannot.
Yeah, I got to see that order. I got to scrutinize that order, because if you can't even ask the witness who hired them, that's a problem.
That's a real issue. Thank you, Michelle Foster, for that donation. While we have this up, everyone, please hit the like button while we're on it. Really appreciate it. So that's really an issue. So I want to see the order so we can suss that out a little bit more on it. But apparently she's not going to allow them mention that there was a federal investigation and why they were hired, and maybe they can say they were hired by the federal, but doesn't the door get open when Hank Brennan starts questioning about who paid them and when? I mean, how does it not come in?
Of course. Well, I know what she's trying to do, and that is prevent the trial within a trial, where then the prosecution starts to go into the whole, when did you send an email, and when did they respond, and when was the money paid, which as I've said before, bring it all on. Let it all come in. Let the prosecution do their best to damage that independent relationship. But if it's going to be shut off for both, I think the defense is the loser.
Right. Or she allows it a certain way for the prosecution. Well, you got paid X amount of money from the defense, did you not? And then doesn't allow the whole history of it to come in. That's or limits them to say, well, we were hired by some other third party that's not in this courtroom. That's bad.
Yes.
That's bad.
that is that in-depth legal analysis. I agree with. That's bad.
That's bad. But I can't put anything, after seeing all this, I can't put anything past the defense being cut off of the kneecaps, And that's not to say, you and I haven't discussed, we get accused of being a pro Karen Read. We've said we're pro the prosecution proving the case beyond a reasonable doubt, and we've taken heat when we've said we can see situations where Karen Read could get convicted of manslaughter on certain theories if the prosecution went there. We've said that,
No doubt about it. I mean, I think that would be the easiest case, easy in quotes. Rose Harvey says Brennan was lucky Sisiski didn't have grave concerns. No, he did not have grave concerns. He did his business. Yeah.
And no grave concerns. And Jerome Street donation. Thank you, Jerome. Thank you for coming back. Thank you for being back. We appreciate it all. It's beyond me. It's part of it seems almost like it's because this was rushed, right? So we can't do it. We're rushed here. The second thing is, I still think something happened, not with the knock. Well, maybe something happened when the defense made a big deal out of Judge Cannoni not bringing the jury back to investigate what their verdict was. Although now that I learn about juror number 1 being the police officer, he seemed to be the person, from what I gather, was most, at least what's been written about, was gearing towards a conviction, at least on the manslaughter issue, right?
Right.
I could see why she didn't bring them back, but you never know. I mean, you just don't know what happened, and maybe the defense, she felt the defense went after her too hard. But I thought I saw a perceptible change. I told you, and I've said this over with the ARCA, the whole ARCA issue, when Hank Brennan said that the defense didn't turn over the fact that they had been paid, but that didn't come until after the other trial had ended and there was a bill submitting back to the defense for the testimony or whatever. We haven't seen the light item bill. So, I thought I saw a shift. I felt a shift by her then.
Yeah. I mean, if that was all she needed to tip her over, obviously she wasn't a fan from the start, but maybe that was what did it for her. And of course, we all think that was an overreaction anyway, based on what we all learned at that point. We didn't know, ooh, what could this possibly be? Yeah. And then, maybe not such a grave concern issue.
Yeah. So that was one of the things that was left over from last week. We're not going to know about this reconsideration that the Commonwealth has fired, allowing the defense dog bite expert to respond to the dog bite expert that the Commonwealth now has, the new expert. We don't know what that's going to happen. I assume that's going to be decided on tomorrow, and she'll put that forward tomorrow, right?
She's not asking for any more argument on any of this stuff.
No, right? And we still don't know about the redacted presentation that of Mr. Welcher, Dr. Welcher, Judson Welcher. He was the neurosurgeon that's been called in, who has apparently how many PowerPoint slides?
That's another one that bugs the hell out of me, because it came up so many times. This guy has this 140 slide PowerPoint presentation going through all of his opinions, even though the court has suggested, and the parties, at least on the record, have agreed that there are some of those opinions that are inappropriate and that will not be elicited by the prosecution. So what happens? They've sent that presentation. The prosecution has sent that presentation to the defense twice now. Each time it's the same 140 slides. Each time it's all the same issues that are disputed and are going to be inappropriate and not allowed in as part of that expert's opinions. But it's like,
well, I'm going to leave everything in there and then find out whether it makes it through.
Yeah.
You know, like he's trying to just shove it through, and maybe in all the craziness, nobody will notice. But they did notice, and the defense is still screaming about it. So that's yet
Yeah.
to be resolved.
Yeah. And then the other thing that happened today, kind of related to this case, and it'll affect our show on Wednesday. Michael, I don't know if you saw, we posted it on Justice Serve TV. Apparently, the medical examiner, it's kind of interesting, because the medical examiner in the Sandra Birchmore case, now that's in the neighboring county, but it's the Boston office, right?
It's right there. It's right there. So
has decided that they will not change their opinion that Sandra Birchmore's death was a suicide. They're going to keep it as suicide. They're not going to rule it as a homicide. As you all know, my husband's involved in the civil case. The feds are involved, have indicted the person that they believe is the killer, but not under a murder statute. It's under a civil rights statute. She is not. He has not been indicted by any state jurisdiction for any crime relating to Sandra Birchmore. And this is such a hot button topic that we're gonna go there. It's kind of interesting that in the Reed case, you have an undetermined manner of death, right? That there was pressure on the medical examiner. We've read, and I think she testified to change it to a homicide, which she wouldn't. So she is now apparently going to be cross-examined by the state, not be, and let the defense put her on. And in the Birchmore case, which has I read today a May 6th or May 5th date, because after the new administration came in, things were put on hold for a while.
It's a federal case, so
a federal case.
Yeah.
And it's not a murder case. You have a medical examiner that, despite two other forensic pathologists or death scene doctors' opinion that this was a homicide, will not change the opinion unless new information comes to them. Okay, so we will examine that at great length. And we have Mizzy, that was mentioned in Will DeGlara's program. She is going to be joining us. And I think if Dizzy could put up her website page, that would be great. She is joining us, and she knows everything there is to know about the case as to why the failure to review it, and quite frankly, the failure to change it to a homicide, gives the state an out to say, well, then we're not going to prosecute this or look at anybody for murder because we don't have any determination.
Well, I understand her position. It's a damned if you do, damned if you don't, because either she goes in reinforcing her original position, right or wrong, right? We got experts saying it's wrong, or she flip-flops. Either way, she's doomed in terms of credibility. Either they're going to have experts that refute what she says, or she's going to change her own opinion. It's a bad place to be if you're her.
But we will put up the statement from the supervisor of that office as to why they won't, because I guess they're waiting for new information. We'll put the whole statement up on Wednesday's show.
Yeah, that's funny. I remember how they phrased it. It was, the medical examiner's opinion is only as good as the information available at that time. Right. So that begs the question, okay, what didn't you know? What did you not have available that these other experts, including Dr. Michael Bowden, that they had that came to the opposite conclusion? Because I think homicide is the opposite of suicide. So what were you missing? That's what I want to know. What do you think you needed to change your opinion? Right.
And so a part of our show on Wednesday, we'll probably devote a whole hour on that, and then whatever time we need, obviously, on the updates on this case, the Karen Reed case. And we're also going to try to look at this week a couple other cases that we'll have in addition to every night's update on the Karen Reed jury selection. We're going to try to look at the Kohlberger case. We're going to try to give a preview of the Donna Adelson case. And there's also another little case that started today in Phoenix, Arizona, Michael.
Yeah, Lori Daybell no longer wants to be known as Lori Vallow Daybell. That jury selection started today as well. And I think that one's going to take maybe a week, maybe touch longer. I think far less than it will take for a jury to be impaneled here in Dedham. So what we'll do, because once the jury selection process kind of grinds into routine, barring day-to-day craziness, we'll be able to get into some of the cases that we haven't really had a chance to do, including that one. And I know a couple of relatives from the Vallow family that we may be able to bring on and talk with, so including one of her brothers.
So we're going to try to deal with that. So we're going to try to maybe either run those live, run those tape, whatever, have previews on those, but continue our nightly coverage of the jury selection and bring it to you from Justice Served TV. And by the way, Michael Bryant will be still in Dedham.
Yes, Dedham.
Dedham. Was close to Ken, and he's going to be posting a couple things. What are you posting? Because you did some drive.
Well, I did do the what I did was a real-time drive from 34 Fairview to 1 Meadows Avenue. I had never been on that route before, but based on the evidence, neither had Karen Reed that night because she had never been to 34 Fairview, right? So I wanted to find out how long it took. Obviously, I'm not in the middle of a blizzard, and it's not at night, so traffic was probably a little bit higher. Weather was better. Anyway, a totally unscientific way of getting a sense of how long it takes to get from point A to point B, and I just recorded that real time, posted that for our members. We'll unlock that for everybody as soon as we're done tonight. But I think it's interesting just to get a sense of, the spatial orientation there, kind of our own little jury view as it relates. And the important part of that is, as people will remember, the Wi-Fi at 1 Meadows, John O'Keefe's home, clicked on to Karen Reed's phone at or about 12:36. So unless you can dispute that, refute that, adjust that, correct that, it does cause some problem with the prosecution's timeline because at least Lally, and I remember other references, he said whatever happened at 34 Fairview was at 12:44. Well, that's 8 minutes after the Wi-Fi connected to Karen Reed's home at 1 Meadows Avenue. So explain that away. It's got to be dealt with, but I thought it'd be interesting just to see how long it takes. It took me about 6.5, 7 minutes to make that drive. Okay. And I think that's going to become an issue in the second trial. So I thought it'd be worth looking at. And then I also did just a real quick video to get a sense of what the jury will see as they pop out this door and get ready to maybe be selected for the Karen Reed Part 2 trial. We'll see. And
do we know what time we're starting tomorrow? Because everyone's been asking, are we streaming?
I know.
What's
we're gonna have to figure that out. I think it's 9 at the very earliest, but that's all I can say.
Right. And
maybe we're early enough to go up to the court and ask.
Yeah, and maybe we will try to, if possible, we'll try to also then run your drive-throughs, even though we're posting them. We'll try to run them on the show tomorrow and try to hook up with Tom. Apparently, he may have been waiting for the link, but I think it's a little late for tonight to start with him. The link now. We'll get him on. Maybe tomorrow. Yeah, we'll get him on tomorrow. With that,
maybe I can get some some opposition to, I should say, prosecution opposition to the Free Karen Reed movement. Got to be some people that are willing to talk. So we'll. So
Michael, this is the jury selection won't be broadcast, so nothing to stream. But it may be interesting to stream 9 o'clock to 10 o'clock, 8:30 or 9 o'clock to 10 o'clock, just to see what's happening around that courthouse.
No doubt, it'll be a very interesting scene setter because I expect that folks will be out full-throated.
Full-throated. So is that our plan then? We'll be on the air 9 o'clock tomorrow morning?
Okay. That sounds good to me, unless we hear otherwise. Let's do
that.
And
then we'll probably have our regular show tomorrow night at either 5 or 6. I'd like to get Michael Bryant on the road to go home if indeed nothing is happening, but I'm sure something is going to be happening.
Yeah, we'll stick around and see what happens tomorrow. But in the meantime, try to do the right thing. I'm Michael Bryant. We'll see you then.
And see you at 9 o'clock tomorrow morning. I'm Linda Kenny Bowden. Together we are Justice Served TV. Before you go, please hit that like button, subscribe, share, and that notify bell. See you tomorrow.